And without further ado, we go into the first session of this webinar. It's a weekly webinar. It's a webinar that will happen 4 times this week. We will have 4 talks, and the first speaker is Professor Sergey Sayapin. He teaches at KIMEP University in Almaty, Kazakhstan, talking about human rights in the post-Soviet Central Asian space. Sergey is an international lawyer, and I'm very much looking forward to his talk. You will speak for 30 minutes, and then we will have time for Q&As. Sergey, you have the floor.
Thank you very much, Professor Mia. Dear colleagues, ladies and gentlemen, I am pleased to address you today on such an important topic. Before I proceed to the substance, let me start with a few disclaimers. First, I understand that my talk will not be complete. The talk is about human rights, but its limited volume compelled me to mention some and omit others. The focus is on civil and political rights, although economic, social, and cultural rights are also dealt with. My talk is about Central Asia, but the truth is that there is no single Central Asia, and not only the Central Asian states, Kazakhstan, Kyrgyzstan, Tajikistan, Turkmenistan, and Uzbekistan differ from each other, but also each of them displays important internal differences. Such differences, for example, competition for power between regional clans, inform regular political processes within the states, but on a few occasions, they have resulted in situations of violence. All Central Asian constitutions contain provisions about the democratic character of their respective political regimes, but Central Asian politicians often insist that democratic practices in the region are specific, and some facts, which the West interprets as human rights violations, merely testify to local particulars justifiable by cultural relativism. The Central Asian states have acceded to all major international human rights law instruments, but much work remains to be done to implement them, in particular as far as the freedom of the press, rule of law, independence of the judiciary, corruption perception, and gender inequality are concerned. Instead of formally listing the international human rights law instruments, which the individual Central Asian states have acceded to, I will highlight some of the most critical human rights issues, along with some of the most notable achievements in each country, in order to exemplify the regional human rights dynamics since 1991. I hope that the interdisciplinary methodology that I will employ will place human rights in a broader sociological context they deserve and exemplify their relationship with political, economic, and other developments in the post-Soviet Central Asia. At the end, I will offer some concluding observations and recommendations. I will speak for about 30 minutes and we'll then have some time to discuss your possible questions and comments. I will discuss the country case studies alphabetically, and therefore will begin with Kazakhstan. An economic leader in the region, Kazakhstan also positions itself as a regional political power with a multi-vector foreign policy. Since 1991, it has been trying to balance its development priorities with other commitments, including under international human rights law, with varying success. For example, in 1993, the Bolashak Scholarship was instituted to let talented Kazakhstani youth obtain world-class higher education abroad. In the same year, a highly efficient human rights NGO, the Kazakhstan International Bureau for Human Rights and the Rule of Law, was established. The Soros Foundation Kazakhstan has been supporting human rights initiatives in the country since 1995. A moratorium on the death penalty has been in place since the 1st of January 2004, and in 2020, last year, Kazakhstan acceded to the second optional protocol to the International Covenant on Civil and Political Rights, ICCPR, and abolished the death penalty in accordance with its provisions. In 2013, a national preventive mechanism, NPM, was put in place to reinforce combating torture and other ill treatment. Since the annexation of Crimea in 2014, the state introduced a program of ethnic Kazakhs' voluntary resettlement to the north of the country, and several nationals of Kazakhstan were sentenced under Article 172 of the Criminal Code for taking part in the ongoing armed conflict in eastern Ukraine. Anti-corruption reforms included the establishment of a very efficient system of e-government, e-gov, and a network of public service centers, TON. In 2020, legislation on trade unions was amended. On the other hand, quite a few issues attracted the attention of domestic and international human rights monitors. As of now, one individual complaint was considered under the optional protocol to the Convention on the Elimination of All Forms of Discrimination Against Women. 15 individual complaints were submitted under the Convention Against Torture, and 45 individual complaints were considered under the first optional protocol to the ICCPR. In December 2011, police used force against protesters in Zhanaozen, as a result of which 17 persons were killed and more than 100 were wounded, according to official data. Domestic violence is unfortunately widespread, and sexual violence, including against children, is a lasting issue. In 2019 and 2020, criminal responsibility for sexual crimes was reinforced. If you wish, you can take a look at articles 100 through 124 of the Criminal Code of Kazakhstan. After the first president of Kazakhstan, Nursultan Nazarbayev, resigned on the 19th of March 2019, Dr. Kasym-Jomart Tokayev was elected president on the 9th of June 2019 and heralded a number of important human rights reforms. In particular, the concept of a hearing state was announced with a view to improving the quality of dialogue with the civil society. Legislation on peaceful assemblies was revised, and in 2021, a reform of electoral law took place. In 2019, the Ministry of Justice initiated amendments to the law on advocacy and legal aid, which caused much controversy between the state and legal advisors. For those of you who do not know what this proposed reform was about, I'll summarize it for you. The idea was to establish a Republican chamber of legal advisors that would involve all legal advisors in the country. The idea about the chamber was that it should control the quality of legal advisors' work, but what caused controversy in the public was the introduction of mandatory membership and the introduction of mandatory membership fees in this Republican Chamber of Legal Advisors. So there was a considerable protest among legal professionals in the country, and as a result, the following measures were taken. Throughout 220, the draft amendments were the subject of heated discussion in a working group composed of policymakers and practicing lawyers. On the 12th of May this year, President Tokayev requested the Constitutional Council to assess the compatibility of the proposed amendments with the Constitution of Kazakhstan. On the 4th of June 2021, the Constitutional Council found, I quote, "the lack of clarity and inconsistency of some of the proposed provisions with related norms, which might create conditions for their ambiguous understanding and improper application," end of quote. At the same time, the Council ruled that the amendments were compatible with the Constitution and they were adopted. They were adopted not exactly the way they were designed. They were adopted with modifications. In particular, membership in the Republican Chamber of Legal Advisors was no longer mandatory but voluntary. And there were also some improved provisions regarding the membership fee. Now, at this very time, the Parliament of Kazakhstan is considering a set of amendments which are allegedly directed at protecting children against cyberbullying, but may result in adverse effects for millions of people. If adopted, the amendments will require social networks such as Facebook or LinkedIn or popular messengers to establish offices in Kazakhstan and to delete content which is deemed unlawful in a speedy manner. If these requirements are not met, the operation of social networks in the country may be suspended. Like some other human rights experts, I believe this proposed regulation is not in line with international human rights law. Talking about electronic petitions, a few days ago, a group of Kazakhstani human rights defenders launched a petition on Avaz against the proposed amendments, which I have not signed though, because the petition does not explicitly mention arguments which I consider essential in this context. True, states may restrict certain human rights in pursuance of a legitimate goal. Protecting children against cyberbullying is certainly a legitimate goal. However, the measures introduced must be proportionate to the goal, and one should not be able to attain the goal in other, less restrictive ways. I believe that the problem of cyberbullying can be tackled in more targeted ways, not leading to the suspension of social networks and messengers as such, because they're used by millions of people. Now let us move to Kyrgyzstan. From my perspective, Kyrgyzstan is a paradoxical nation. Often referred to as Central Asia's island of democracy, Kyrgyzstan experienced two revolutions in 2005 and 2010, which suggests, in my humble opinion, that the political system's ability of peaceful power transition is limited, albeit in a way which is different from its neighbors. The country's political landscape has been dominated by competition for power between the North and the South ever since 1991. Organized crime is another serious factor in the country. Kyrgyzstan seems to retain a relatively strong Soviet legacy. For example, the statues of Lenin, Marx, and Engels are standing in the center of Bishkek, and the Party of Kyrgyzstan's Communists is active. Russia's influence in politics, economy, military affairs, and higher education is strong. Kyrgyzstan is a member of the Eurasian Economic Union since 2015. It hosts a joint Russian military base, and the Kyrgyz-Russian Slavonic University, KRSU, was established as early as in 1992. At the same time, Kyrgyzstan's higher education market also hosts the American University in Central Asia since 1993 and the OSCE Academy since 2002. Until this year, non-governmental organizations, including international and local human rights NGOs, could operate relatively freely. As of now, one individual complaint was submitted against Kyrgyzstan under the optional protocol on the Convention on the Elimination of All Forms of Discrimination Against Women, and the Human Rights Committee considered no fewer than 43 individual complaints under the first optional protocol to the ICCPR. Violence against women and girls is frequent, although explicitly prescribed by Article 175 of the Criminal Code. Bride kidnapping remains a problematic issue in the country. Massive violence which erupted in the south of the country in June 2010, and according to Human Rights Watch, which amounted to crimes against humanity, has not been fully investigated, and a prominent human rights defender, Azim John Askarov, who had been given a life sentence, died in prison in July 2020. Since 1991, Kyrgyzstan enacted 3 constitutions, as we discussed earlier today, in 1993, 2010, and most recently in 2021. The 1993 constitution was amended on several occasions with a view to reinforcing the authority of the president. After Presidents Askar Akayev and Kurmanbek Bakiyev had been ousted from their offices inter alia on the grounds of corruption and abuse of power, the 2010 constitution replaced the presidential republic with a parliamentary one. The most recent constitution was enacted on the 5th of May 2021. Human Rights Watch, and please note these are not my observations, but those of Human Rights Watch, observed that the new constitution consolidated the power of the president again, in that it transferred, I quote, power from the parliament to the president to appoint members of the cabinet and appoint and dismiss judges, the prosecutor general, the chairman of the National Bank and of the accounting chamber, as well as nominate and dismiss half of the Central Election Committee, undermining their independence from the executive, end of quote. Again, according to Human Rights Watch, the new constitution also placed restrictions on the rights to freedom of expression, assembly and association, and introduced new regulations for NGOs and political parties. It remains to be seen where this trend will take the country. Now let us say a few words about Tajikistan. Complicated by religion, competition for power among regional clans, social traditions, and the enduring legacy of a violent non-international armed conflict which took place between 1992 and 1997, the human rights situation in Tajikistan is quite tense. Domestic violence is widespread and early marriages occur. Arbitrary detentions of opposition supporters and attacks against journalists have been reported in the country. The situation is exacerbated by the weakness of Tajikistan's economy. In 2019, personal remittances received by families of Tajik labor migrants working abroad, primarily in Russia, constituted 28.6% of the overall GDP. Like in Kyrgyzstan, Russia's influence in politics, military affairs, and education space of Tajikistan is extensive. For example, Tajikistan hosts the 201st military base, is a member of the Collective Security Treaty Organization, CSTO, and the Tajik president Emomali Rahmon, who'd been in power since 1994 and appointed his elder son as mayor of Tajikistan's capital Dushanbe in 2017, was the only foreign head of state present at the annual victory parade in Moscow this year. The Russian Tajik Slavonic University, RTSU, was founded in 1996 and is among the most popular higher education institutions in Tajikistan. Last year and this year, Russia should have invested up to $30 million in the construction of Russian schools in Tajikistan. According to Article 2 of the Constitution of Tajikistan, Russian is the language of inter-ethnic communication. With all these factors in place, the influence of Russia in Tajikistan is going to stay for decades to come. As of now, the Human Rights Committee considered no fewer than 29 individual complaints under the first optional protocol to the ICCPR. The COVID-19 pandemic posed a serious challenge to Tajikistan as it did to the other Central Asian nations, including in terms of respect for human rights. Tajikistan did not acknowledge the existence of COVID-19 on its territory until the 30th of April 2020. According to Human Rights Watch, I quote, Tajik authorities have provided some information about how to prevent the spread of COVID-19 on government ministry websites and have visited some schools, universities, and army bases to inform people about the disease, end of quote. Still, they have not imposed a quarantine or encouraged social distancing in any meaningful way. The government did not cancel Nowruz, or New Year, festivities in late March, and schools, businesses, and most public spaces remained open, end of quote. Obviously, above and beyond the right to the highest attainable standard of health, the COVID-19 pandemic affected throughout Central Asia, inter alia, the right to education at all levels, access to justice, as well as the rights to the freedom of movement, expression, and assembly. Turkmenistan. As far as Turkmenistan is concerned, it is the most complex Central Asian context. The political system is rigidly controlled by the president, and independent human rights scrutiny is very difficult. In 1985, Mr. Sapar Murat Niyazov became first secretary of the Turkmen Communist Party and remained in power as the first president of Turkmenistan until his death in December 2006. During Mr. Niyazov's time in power, opera, ballet, and circuses were banned in 2001. The months of the year and weekdays were renamed in 2002, and his two-volume book, Ruhnama, became mandatory reading at all schools, higher education institutions, and government agencies. Its knowledge was required even to qualify for a driving license. And quotes from Ruhnama, along with those from the Quran, were built into the walls of the Turkmenbashi Mosque in Turkmenistan's capital, Ashgabat. Mr. Niyazov's successor, the current president of Turkmenistan, Gurbanguly Berdimuhamedov, also possesses sweeping power in the political system and holds the title of Arkadag, the protector. His only son, Serdar, was a member of parliament, held a few posts in the executive, and was appointed deputy chairman of the cabinet of ministers on the 11th of February 2021. As of this year, Mr. Berdimuhamedov published more than 55 books on various subjects, some of which, in the words of Novaya Gazeta, people worship like bread or the Quran, end of quote. Meanwhile, the mass media are strictly censored, access to the internet is limited, and political dissent is suppressed. The social and economic situation in the country is complex. As of October 2021, Turkmenistan has not reported a single COVID-19 case. But already in July 2020, the World Health Organization advised the Turkmen authorities to take critical public health measures as if COVID-19 was circulating. On the 3rd of June 2021, the International Bicycle Union announced that the 2021 Track Cycling World Championships, which were announced to take place in Ashgabat in October 2021, I quote, have been cancelled in their initial format at the request of their organizers, as the health constraints and restrictions linked to the COVID-19 pandemic make it impossible to stage the event in the country. Earlier in 2021, food queues were banned in order not to discredit the president. As of this time, the Human Rights Committee considered no fewer than 23 individual complaints under the first optional protocol to the ICCPR. So if you compare these figures with the figures of other countries, you will see that it's lower. However, the fact that the other Central Asian countries' statistics are higher must be due to practical obstacles in communicating the Turkmen cases to the Human Rights Committee and other human rights organs. And last but not least, a few words about human rights developments in Uzbekistan should be said. Although the Universal Declaration of Human Rights was the first international legal instrument ratified by Uzbekistan after proclaiming its independence in August 1991, until 2016, the human rights record of the post-Soviet Uzbekistan was consistently problematic. Indeed, Human Rights Watch called it abysmal. The powers of the Ministry of Interior and the National Security Service were sweeping, and it was not until 2016 that a law on internal affairs bodies was adopted, and the National Security Service was reorganized into the State Security Service in 2018. As of now, one individual complaint was submitted against Uzbekistan under the Convention Against Torture, and the Human Rights Committee considered no fewer than 53 individual complaints under the first optional protocol to the ICCPR. According to the former United Nations Special Rapporteur on Torture, Theo van Boven, torture in Uzbek places of detention was systematic at the time of his visit to the country in 2002. The name of Jaslik, a detention facility in the west of the country, became synonymous with ill treatment. The second president of Uzbekistan, Mr. Shavkat Mirziyoyev, ordered the closure of Jaslik in 2019. On the 13th of May 2005, a protest in the eastern town of Andijan was suppressed, and strict measures against civil society and foreign and international organizations represented in Uzbekistan followed. The death penalty was abolished as of the 1st of January 2008. According to the International Labour Organization, the use of forced labor, including child labor, in the cotton harvest was systematic and systemic in the country until a report issued in early 2021 confirmed that, I quote, systematic child labor has been eradicated and child labor was no longer a major concern, end of quote. According to the same report, and I quote again, the Uzbek government has significantly increased wages since 2017 and introduced a differentiated pay scale so that pickers are paid more per kilogram of cotton towards the end of the harvest, when conditions are less favorable and there is less cotton to pick. This has led to a significant drop in the prevalence of forced labor, end of quote. The government has also recognized the issue of labor migration and started taking measures to improve the situation of labor migrants abroad. Progressive reforms carried out in Uzbekistan since 2016 are yielding fruits. For example, the number of acquittals in criminal cases increased significantly since 2017. In 2018, President Mirziyoyev mandated a revision of the criminal and criminal procedure codes of Uzbekistan, among other things, with a view to filling gaps in criminal law and procedure, resulting in inadequate protection of human rights and freedoms. Although the draft of a new edition of Uzbekistan's criminal code does contain a few notable improvements, it has also attracted some criticism on the part of international human rights experts, in particular in the context of offenses relative to the exercise of the freedom of association, domestic violence, LGBT rights, and criticism of public figures. Uzbekistan is now cooperating with expert organizations such as the International Commission of Jurists on the implementation of international law, in particular on economic, social, and cultural rights and access to justice. This is important. On the 21st of December 2019, The Economist, the journal, opened that no other country has advanced that far in 2019 and named Uzbekistan Country of the Year. In early 2020, Uzbekistan announced the completion of mine clearance along its border with Tajikistan. Given that over the past 20 years, a total of 374 citizens of Tajikistan were killed by anti-personnel landmines and another 485 Tajik citizens were injured, the humanitarian significance of this development is outstanding, I believe. On the 22nd of June 2020, the President of Uzbekistan approved a national human rights strategy of the Republic of Uzbekistan, which expounds on 66 pages the functions of various national authorities with respect to the implementation of international human rights law and recommends measures on human rights education. Most recently, just a few days ago, Uzbekistan issued a new passport to Ms. Valentina Chupik, a prominent human rights defender who was expelled from the Russian Federation for 30 years, which enabled her to travel to Armenia and later, hopefully, to Ukraine. Valentina Chupik was actively engaged in defending the rights of Central Asian labor migrants in Russia. And I like to think that Uzbekistan's decision to issue her with a new passport was a wise and elegant signal sent to the Russian authorities to the effect that Uzbekistan's human rights policies are now changing for the better. Dear colleagues, and now with your permission, let me turn to a few concluding remarks. Now, 30 years after the dissolution of the Soviet Union, the Central Asian states are still learning to apply international human rights law and to communicate about it with external and internal audiences. Most recently, the COVID-19 pandemic exposed numerous practical human rights issues in Central Asia, and not only with respect to the right to healthcare as such. For example, access to information was not always consistent. Statistical methods employed were at times contradictory. The legal status of regulations issued by the chief sanitary doctors was uncertain, and the legal challenges posed by the state of emergency regime were plentiful. The transfer of education online was not a satisfactory solution in terms of quality for families with many children, where there was not enough hardware to let children attend classes simultaneously. Defense lawyers reported that online, civil, but also administrative and criminal trials via WhatsApp were not a good solution either, among other things, due to the limited number of participants in a session and difficulties related to the examination of evidence. The consequences of these ad hoc solutions are yet to be seen, but there are also useful lessons to be learned. I believe that the Central Asian states should invest as a matter of urgency in the digitalization of their administrative procedures and other state services. Doing so will increase the efficiency and speed of such procedures, significantly reduce corruption risks, and visibly improve the quality of dialogue between governments and civil society. Further, instead of introducing new rules, regulatory barriers should be taken down wherever possible, especially in the field of economy. Greater transparency and accountability should be achieved in political decision-making. As a result of such reforms, economic and political systems will be modernized and the quality of life will grow. The political tradition in the region is such that workable reforms will only originate at the top of the political systems. This means, in effect, that governments should realize that compliance with international human rights law is not harmful to the state and will, in the language of Uzbekistan's new human rights strategy adopted in 2020, contribute to, I quote, further strengthening the country's authority in the international arena, in particular to improving the position of the state in economic, political, and legal rankings and indices, end of quote. International human rights are closely linked with all areas of life, and respect for human rights is an important indicator both for international investors and policymakers, because it testifies to the stability, predictability, and trustworthiness of a state's judiciary and law enforcement system. Judges, especially those dealing with criminal and administrative cases, and law enforcement agents ought to be trained on the application of domestic and international human rights law. And states should genuinely align their law enforcement practices with their obligations under applicable human rights instruments. Importantly, international human rights treaties and constitutional provisions on human rights should be directly applicable in domestic legal orders. And of course, resolute measures must be taken to combat torture and other forms of ill treatment. The legal status and influence of national human rights institutions should be elevated further, and they should be staffed by individuals with professional knowledge of international human rights law, international humanitarian law, and international criminal law. Regular dialogue with the United Nations human rights organs, international and domestic human rights NGOs will be helpful, and the cumulative effect of all such measures will benefit individuals, society, and the state alike.